I'm Drew Stevenson, and this is a lecture about the case Chamber of Commerce versus Reich, a DC Circuit Court of Appeals case from 1996 about the reviewability of presidential actions. This is for my administrative law course, and it's going to connect the part of the course where we talk about the availability of judicial review with an earlier part of the course where we talked about executive orders like 12866 and so forth. And so let's look at what happens in this case. We start with President Clinton. President Clinton issued an executive order that prohibited federal agencies from contracting with private firms that hire replacement workers during a labor strike. And this had far-reaching consequences. Almost a quarter, 22% of the US labor force at the time worked for federal contractors or subcontractors. In other words, they worked in for private companies, but those companies had gotten lucrative federal contracts. And so the work that people were doing was kind of indirectly for the federal government. And our problem here is that there was a federal statute that actually permitted employers to hire replacement workers during a strike under certain circumstances, or as long as they satisfied certain criteria. Now, President Clinton's Secretary of Labor at the time, Robert Reich, was responsible for implementing and enforcing the order. So he became the named defendant in the case, even though the opinion focuses on the question of whether judicial review was available for president's executive orders. So for my students, don't get too distracted about the secretary here. We're really focused on reviewability of the president's actions. The Chamber of Commerce is a trade association for businesses. And so they're really representing the employers who have employees that are going on strike, and the employers want to hire someone to replace the people that are out on the picket line and to keep their business running. And so they challenged the order and the Department of Labor regulations implementing it. And remember that under Dalton v. Specter, the court had held that the president is not an agency under the Administrative Procedure Act. So the Chamber of Commerce couldn't really seek APA review of the executive order. They actually could probably have challenged the regulations themselves under the APA, but they didn't do so. And the court explains it's partly because of the timing of when the regulations came out and when the lawsuit was filed and so forth. So in terms of our holding, the court held that it basically couldn't review the case under the APA as a challenge to an executive order. And you may remember when we talked about executive orders in another part of the course, we explained that they're not really subject typically to immediate judicial review. They don't create any rights or causes of action. But the court said that it could review the case as what's called non-statutory review. And I know this can be a little confusing for students because we're about to talk about a statute, but the issue here is that we don't really have a statute that created this cause of action or gave anyone the right to challenge the agency's action in court. But we do have a statute that permits the exact opposite of what this executive order forbids. It permitted employers to hire replacement workers during labor strikes under some circumstances. And the order, as I said, prohibited this for federal contractors. Now, here's a highlight. This isn't a quote, but it's the part of the opinion you should kind of pay attention to. For this idea of non-statutory review, which is admittedly an obscure area of administrative law, the court relied on an old Supreme Court decision from 1902, the American School of Magnetic Healing, and which basically no court had followed since the APA's enactment in 1946. And the case itself had created a stir when it was decided because it was a departure from precedent. So some legal scholars really think that the court's relying on a case that was an outlier or kind of a blip. It was a departure from precedent, and then it wasn't really followed very seriously afterwards. But here it is, and it's the basis for this case. Now, also, lest you get confused, we don't see a lot of these cases, partly because there's normally some official other than the president, basically an agency director, who has final implementing authority under federal statutes, even if there's a relevant executive order kind of spelling out how it should be implemented or the coordination between agencies and things like that. And so this means that when you're unhappy with something that an agency is doing, it's really rare that you would need to sue the president directly. And in fact, it actually wasn't really necessary here, the court says. The plaintiffs could have amended their pleadings in time, but they apparently thought that they couldn't. So if the petitioners, and that's the employers, remember, it could have obtained judicial review of the Department of Labor's rules under the APA as well. And the court here says it doesn't matter because they would have reached the same conclusion, that the president has no independent constitutional authority to make labor policies for federal procurement that basically supersede or contradict a congressional statute. Now, where does this leave us? Well, the case is kind of significant because it broadly affirms the idea that federal courts, under their general jurisdiction, have the power and maybe the responsibility to hear cases challenging a government action as a violation of the Constitution or a statute. In other words, we call it non-statutory review because we don't have a statute that says basically authorizes lawsuits under that statute, but we have the government acting in a way that is in contravention of law, that it seems to violate either the Constitution or a statute. And so the courts have got to be there for some reason, and they're basically saying we're here to review that. And that concludes our brief lecture about Chamber of Commerce versus Reich.